Thank you all for coming. I'm Chris Katropia. I'm a law professor at the University of Richmond. Welcome to the 10th annual Evil Twin Debate, brought to you by the Intellectual Property Institute at Richmond, with immense help this time around to Golden Gate University and Bill Gallagher and the students. Thank you so much for having this venue. And thank you to the AALS IP section, Jessica. We've been able to kind of take this on the road. This is the second year we've done this, and it's kind of fun because we get to share this with you all. Not that we wouldn't want you all to come to Richmond. We'd like that too as well. And so, some of you maybe have seen Evil Twin Debate or have it before. Essentially, it's founded on the concept that there are experts. Yes, we still have experts that are often at loggerheads on a specific issue, but they're friendly on a personal level, and so we thought we'd kind of take both of these things and bring them to the forefront, right? Have a nice, collegial and a little bit lighthearted debate about a topic that's timely from two great individuals. And so we're going to do that here today. I can't think of a better topic and group to have the 10th annual debate. With us here, we've got Rebecca Tushnet from Georgetown Law Center, Mark Limley from Stanford Law School, and the debate topic today is free speech or free to reject, trademark registration, and the First Amendment. For the non-IP folks in the room, if there's such a thing, there is. We have some. The Supreme Court actually is taking up this issue of whether the United States Patent and Trademark Office can reject trademark applications for disparagement reasons. Actually, the argument, I think, is January 17th. It's fairly close here. And we actually have two individuals that have written amicus briefs, or one maybe joint amicus briefs, other written amicus briefs on both sides of this issue. The way this is going to go is that Rebecca will have 15 minutes to present her argument. Mark will then have 18 minutes. And then Rebecca will have 3 minutes to rebut. We'll then open it up for questions. And then after questions, we'll have a reception over there sponsored by the ALS IP section and a number of other schools. I can't, apologies. Everyone sponsored. Exactly. Raise your hand. A key kind of tradition for the Evil Twin Debate is that to kind of set the tone, we actually have each of the debaters draft the introduction remarks for the other debater. So what's going to happen here is Mark is going to present the bio or introduction for Rebecca, and then Rebecca will present the introduction for Mark, and then Rebecca will get started with her opening argument. So without further ado, Mark, please introduce one of our evil twins, Rebecca.
Okay. So Rebecca Tushnet, for those of you who don't know her, is the uber geek. She's the world's single most comprehensive source for what's new and cool in science fiction, fantasy, music, and geek culture. Comic-Con arranges its schedule around her. I would have nothing to read and no TV shows to watch if I didn't regularly have dinner with her to get updated on what was cool. She's so up on popular culture that she probably knew who the slants were before they even showed up on the train. And her laptop keyboard is a thing of beauty that must be seen to be believed. When she's not defining the standard for nerd cool, Rebecca is a law professor at the Georgetown University Law Center. Beginning later this year, she will move to Harvard Law School, where she will occupy the coveted position of professor of patent law, or at least something that non-IP faculty at Harvard can't distinguish from that. Thanks to her knowledge of time travel and teleportation, she will teach full-time at Harvard without ever actually leaving Washington, D.C. Rebecca managed to get an article about IP law accepted by the Harvard Law Review when she was not even a professor there, a feat that scientists had previously concluded was not actually possible in physics. Now that she's actually on the faculty, the rest of us needn't even bother submitting articles. Authors and artists who want to be cool come to Rebecca for advice and legal counsel through the Organization for Transformative Works, which she founded. And just to sort of top it off, if I didn't mention it, she's one of the top debaters in the country in both high school and college, making it to the finals in both the Tournament of Champions in high school and the National Debate Tournament. And she still trains high school debaters to this day. So my only hope, I think, is that because this is called a debate, she will revert to debate mode, and everything she says in the next 18 minutes will be incomprehensibly fast.
Okay. Well, I've been given given a tough hill to climb with that introduction. How about this? Mark Lemley is better than you. And he has a bigger laptop. Mark is a leading light on patents, trademark, antitrust, and copyright. I can usually say that he has more citations than the rest of us put together, but tonight my father is in the audience. And so we can only say that he has more citations than the rest of us minus Mark Tushnet. Mark teaches at Stanford and has an active litigation practice as well that includes multiple arguments before the Federal Circuit. He can write an article in 3 days. He can also do a headstand, and he turns out to be an excellent shot. The first time he went shooting, making him a good person to have on your side in the zombie apocalypse. I think that's...
Since we're in a zombie apocalypse,
follow him! So, in terms of our topic, I actually want to frame this as questions of 4 big things that the parties in TAM and the amici disagree on, and then some thoughts about vagueness and inconsistency in 2A refusals. So first, the parties and amici disagree substantially on whether 43A1A incorporates the same policy-based limitations as registration does under Section 2. If 43A protection is still available when use of an unregistered symbol causes confusion, then the impact of denying a registration will be much less, although it will still exist. The problem for those arguing that 43A is still available, like the government, is that the text of the provision leaves us with no real way to distinguish the bars in Section 2 that we definitely want to apply to 43A, like the bar on protecting generic terms as such, from the bars that we don't hear disparagement. So right now, because of the generalized incoherence surrounding registration and infringement and their relationship to each other, you get cases like Belmora in the Fourth Circuit, now the subject of a pending cert petition, which essentially removed territoriality as a limit on 43A by saying that none of the restrictions in Section 2 that made a mark unregisterable necessarily prohibited protection under 43A. Then, by contrast, the Renna case from New Jersey says that Section 2 registration barred mark, because it was insignia of a government entity, couldn't be protected by 43A, and explained why it thought that such a result was sensible in light of the underlying policy behind the Lanham Act, as well as questions of administrability. Regardless of which way one comes out on Belmora and Renna, the point for me is that this question has many implications far beyond disparagement, and I think it's a bad idea to try and answer that broader question merely as a way station to the First Amendment question being litigated in TAM about disparagement. And one of the concerns that led me to participate in the case was that the court would not notice that it was making a very important and much broader statement if it opined on that on the way to a result. The second thing, and here I think I'll start to disagree with Mark, is trademark's effects on non-owners or non-registrants. So in what way, if at all, should it matter that granting TAM a registration enhances his capacity to suppress the speech of others? And this is something that those on TAM's side, with pretty much the exception of Mark's brief, are silent on because it complicates matters significantly. So the related question and the source of some very troubling inconsistencies in the positions of those on TAM's side is the question, is a trademark commercial speech? TAM says it isn't, at least not always. Some amici say trademarks are never commercial speech because there's always non-trademark meaning in a mark. If that is so, we're subjecting infringement cases to far less scrutiny than necessary under standard First Amendment doctrine. Implicit in TAM's argument seems to be that trademark owners have messages, but infringers don't. But TAM also says that one of his objectives is to prevent a racist band from calling itself the Slants. And I find that irreconcilable. And in fact, Mark's amicus brief is great fodder for this. So Dykes on Bikes wants to control commercialization of the mark outside its control, which is to say it wants to prevent other people from using the mark in expressive ways on t-shirts and mugs. Mark Lemley and Stacy Dogan, among others, have argued that this shouldn't be understood as trademark use. But at the very least, it has both commercial and message delivering aspects. The difference between this, the idea that I want to suppress other users of dikes on bikes, and what TAM wants to do is supposedly the harm done by confusion. That is, denying TAM registration rests on something other than the policy interest in protecting consumers. That's an okay justification, and so it survives whatever First Amendment scrutiny you want to bring. Now, as a matter of First Amendment doctrine, if trademarks are not commercial speech, that's actually not true. And it is important that First Amendment doctrine asks us to start talking about real harm. As we know, there's usually no such evidence of harm from confusion, especially confusion in the mug and T-shirt area, and no legislature has made factual findings that that kind of confusion itself does harm. Mark's brief gives another example of the benefits of registration by pointing to his client's ability to use the Sunrise registration process under the new top-level domain system to control a dikesonbikes.xxx domain name registration, because the URS requires you to have a registration or a court decision confirming that your right is a right before it lets you participate in Sunrise. Like it or not, though, that website would have expressed a message, and not one inherently based on confusion with the existing organization. So we have to recognize that there are speech interests on both sides. That doesn't tell us how to come out on the overall question, but it does indicate that we are dealing here with something other than a prohibition on speech, which so much of our First Amendment doctrine is, and so many of the cases cited by everyone here are about. So, third, a big question, what is the framework that we should be analyzing 2A under? Is it government speech? Is it a question of commercial speech under Central Hudson? Is it viewpoint discrimination? Should we be using the doctrine of unconstitutional conditions or something else? One of the problems, of course, is our extremely ornate First Amendment doctrine, which grows new protrusions every year, and we're kind of stuck with that. But another is the very specific problem of applying the First Amendment to government programs that change the structure of the marketplace for speech. Trademark registration, not to mention trademark infringement doctrine, does that, and that has a profound effect on how we should think about the problem. The government has decided to do things far beyond the common law, even if we decided that the common law was a neutral baseline. The intent to use provisions, nationwide rights in the absence of use, these are really important parts of the registration system, and they go far beyond the common law. Another thing where the government has decided to step into the marketplace, and this will become important for my analogy, is public schools. The government has decided to have public schools, and that's a good thing, but it means fundamental involvement in the marketplace of ideas. When the government is deeply embedded into the structure of an institution, that has to affect our understanding of the government's freedom to make choices about what to support. And it distinguishes programs like registration and public schools from programs where the government sends you to jail if you say a particular thing. So I conclude that, that the best framework for understanding registration should be unconstitutional conditions. In particular, the Supreme Court has said that it is an unconstitutional condition on a benefit when the government tries to leverage its program, leverage its funding to affect speech outside of the program. So as if you take our money, you must condemn prostitution and not advocate for its legalization in all your programs. That's an unconstitutional condition. On that framework, though, there is no effect on TAM's ability to communicate his message outside of the trademark context. He doesn't have to give up the name, the slants, to get trademark protection for his goods and services. And he can communicate every aspect of his message, including the idea that they want to be known as the slants, AKA the slants, and still have the same message. By contrast, for example, a prohibition on copyright for disparaging works, which is an analogy that many have made, would actually require the author to give up on their disparagement in order to get copyright protection. Tam doesn't have to give up on his disparagement to get trademark protection for the thing that he is seeking to get trademark to do, that is, the protection of the link between the source and the goods or services. The fourth big thing that the parties fight about is viewpoint versus content discrimination. The line between the two can be quite unclear, and I think especially in combination with the previous problem, it's very important to understand exactly what the government is trying to do. Is the government trying to discuss or suppress discussion of racial issues? Is it trying to stigmatize abortion? Is it trying to do something else? For better or for worse, the government in Section 2A disparagement is trying to limit registrations to those not perceived as disparaging by a targeted group. To me, that's content discrimination, not viewpoint discrimination. And that matters because, especially when it's a government program, content discrimination is much easier to justify than viewpoint discrimination. The government just doesn't care which person or group you target.
It's good to hear it from the audience.
Yes. Let me try it this way. So the government doesn't care why you chose the symbol at issue. Maybe you want to reclaim the number 14 from non-Nazis. Maybe you want to show your Nazi bona fides. Either way, it's the reaction of the targeted group that matters and not your malign or benign viewpoint. Of course, your choice will express a viewpoint. That's not the issue. The issue is whether the overall system, not just the outcome in your case, discriminates against the owners of any coherent class of viewpoints. Now, one can say that true threats express a viewpoint about the validity of true threats, but that just highlights the point that it's possible to reframe almost any content regulation as a viewpoint regulation. In my opinion, the better path here is to ask, why do we care about viewpoint discrimination? Why do we think it's more dangerous than content regulation? And the Supreme Court has previously said, viewpoint discrimination is when the state is attempting to give one group an advantage over another in the marketplace of ideas. That's just not what the disparagement bar is, because everybody is protected by and protected against the disparagement bar. Relatedly, the applicant's viewpoint about the term or the targeted group matters not at all. The understanding of the targeted group is the key. Many on TAM's side say that consulting the views of the targeted group constitutes viewpoint discrimination, even though heretofore we've always used the idea of viewpoint discrimination to identify discrimination based on the speaker's viewpoint. We could, if we wanted to, create a new category of viewpoint discrimination in the air, to borrow a term from Learned Hand. But if relying on the reaction of the audience to determine registrability makes disparagement viewpoint-based, then so are descriptiveness and deceptiveness, also dependent on audience understanding, and that just doesn't seem right. A final couple of words about vagueness. I think this is frankly the most serious issue for the government, and here I do have to appeal to the nature of registration as a government program in its defense. We're up to 500,000 applications a year. If we're going to have registration as an individualized determination at that scale, we are going to have inconsistencies. And here's where the analogy to public schools comes in. If we're going to have them, then some history teachers are going to give better grades to the same essay than other history teachers, as I suspect not a few plagiarists have learned to their sorrow. You can't have the program at this scale without inconsistency. TAM supporters definitely want registration to continue to exist. The solution has to be dealing with the inconsistency in procedural and not substantive ways. That is, we need mechanisms for making records and challenging adverse decisions. And we have this, although there's a reasonable argument to be made that the TTAB should take more account of our precedents. If we decide that disparagement is too vague, then it will be difficult to distinguish almost anything in trademark that we discuss with our students. The line between suggestive and descriptive, which has, of course, significant consequences for registrability, so too with the line between descriptiveness and genericity, the standard for confusion refusals under 2D, as well as the infringement standard, the definition of false advertising, the definition of dilution, and so on. Somebody like Justice Breyer, who likes to balance, could readily conclude that the game isn't worth the candle for disparagement, but is for these other exclusions. But most of the justices on the court are uncomfortable with that kind of ad hoc balancing. And I fear that if they accept the vagueness argument, they will just encourage other courts to lie about how vague the other parts of trademark law are. And that makes our law less law-like, and I think that's a bad thing. So another thing that Mark's brief excellently highlights is there are a series of contradictory dikes on bikes rulings. One examiner allows it, one examiner refuses it. And this is a great example in terms of vagueness because there's a recent exact match in the genericity space. The mark churrascos, allowed as a standard word mark for restaurants, then rejected for being generic when the registrant tried to register a word plus design mark, a narrower mark. Is this dumb? Yes. Should we change the rules so there's more issue preclusion at the PTO? Maybe, although we have this huge installed base that will make that problematic. But I think we should be asking administrative procedure questions about these. If we constitutionalize this process, we're inviting it to grind to a halt, or to functionally convert into a filing-based rather than examination-based regime, which I think is bad for the system overall. So that's where I have it. We have Henry apart.
So I'm going to start with the idea of viewpoint versus content-based discrimination. I think ultimately it doesn't matter for the outcome of this case because Tam pretty clearly wins either way. But I think it may well matter for some of the issues that Rebecca identified, though not in the way that she specifically indicated. So let me first start by saying that I think under any kind of reasonable way we would think of the term viewpoint-based, this has to be a viewpoint-based restriction on speech. Redskins, if it goes down in the trademark office, right, goes down because we think it's a term that's offensive to Native Americans. If you registered the Washington Native Americans for a football team, there is zero chance, none, that the trademark office would reject it. Why are they distinguishing those two? They are distinguishing those two because they think one message is bad, they want to discourage it, and one message is good and or at least neutral and they don't want to discourage it. Now, why they think it's bad, which is something Rebecca spent some time on, we'll talk about in a minute, although I think from a viewpoint-based perspective it shouldn't matter. Right? The point is that, as the court said in Sorrell versus IMS Health, right, the First Amendment requires heightened scrutiny whenever the government creates a regulation of speech because of disagreement with the message it conveys. And that's precisely what the disparagement rule does. It creates a regulation of speech, a higher burden, because of disagreement with the message that's conveyed. Maybe we disagree with it because we, the government bureaucrat, don't like it. Maybe we disagree with it because we think it will hurt parties out there in the world, hurt the group that's being disparaged. But either way, we're imposing a restriction on terms that we view to be bad, Redskins slants, that we would not impose on Native Americans, celebrations, which is one of the marks that they permit, the NAACP, right, where we would permit National Association for the Advancement of Colored People and deny National Association for the Abortion of Colored People because we think one of those things is offensive and the other isn't. I happen to agree with that statement. I wish the Washington Redskins would get a life and change their name. But I don't think the government gets to say, we don't like it, on the basis of that value judgment, we're going to prohibit it. That, to me, is classic viewpoint discrimination that triggers strict scrutiny. But from the perspective of this case, I don't think it matters. Because at the very least, and I don't understand Rebecca to disagree with this, although some of the briefing does, at the very least this is a content-based restriction on speech. That is, the government is at a minimum restraining the mark, refusing to register it, burdening TAM's speech, precisely because of the nature of that content. It is the content of the mark that determines whether it survives, even if you think they have some sort of a neutral principle they can apply that distinguishes disparaging from non-disparaging marks. And the motive for regulation, why you regulate, doesn't matter. In Reed versus Town of Gilbert, the court said government regulation of speech is content-based if a law applies to particular speech because of the topic discussed or the idea or message expressed. Right? So viewpoint-based, if we're banning it or making it harder because we disagree with it, I think that's true here. But even if you think that's not true, even if you think that's not why the government is doing it, they are surely applying this new and special law because of the topic discussed or the idea or message expressed. That makes it content-based. Right? Now, It is true that, as the government and some of the parties say, right, one of the asserted justifications for banning disparaging marks from registration is they'll upset people. It's not that we, the government, are upset, the argument goes, but the people out there in the world are upset. The Native Americans are not going to like the fact that a disparaging term is used about them. Asian Americans are not going to like the fact that a disparaging term is used about them. And that, I think, is probably true. It does seem to structure how we do the inquiry. It does not make this regulation content neutral. Quite the contrary. In Forsyth County versus Nationalist Movement, the Supreme Court said that listeners' reaction to speech is not a content-neutral basis for regulation. Speech cannot be financially burdened, even more than it can be punished or banned, simply because it might offend a hostile mob. It might be a good reason, perhaps, to do it, but it does not make it a content-neutral reason. It is a content-based reason. Further, the vagueness that Rebecca referred to at the end is a real and significant problem. And one of the things we tried to do in the Dykes on Bikes brief is give one example of the sort of Kafkaesque odyssey that we've gone through over 13 years to try to register the mark, which took 7 years, an appeal, a challenge, a refusal even after the TTAB on appeal ordered the examiner to go ahead and do it. And then, once we got the mark, a separate refusal to register the presumably narrower design mark because it included the offensive words in it. That's still pending, was going to be overturned on appeal, but it's now all on hold, and they may pull everything back, depending on what happens in the TAB case. And all of this happened quite clearly, not because there was evidence that was contradictory about whether or not there was disparaging. The only evidence, we ended up spending a lot of time and money putting in voluminous declarations, the only evidence was that lesbians were perfectly happy with our use of this, that they were not offended by it, that they were reclaiming the term dyke as a whole, and that this was an effort to do so. What we did see was that when the second examiner, the one who was rejected and maintained the rejection of the logo mark, said, well, gosh, this seems like an offensive term. I looked it up on the internet, and there's bad statements that include the term dykes. Counsel who was dealing with the trademark on the phone said, well, but I'm a dyke, and I don't consider it offensive. And she said you could hear an audible gasp from the examiner. This examiner was personally shocked, right? And so I think one of the problems with having the government make a viewpoint-based determination of this sort is that even if we say we're going to apply it by neutral principles, what we end up doing is using government as listener, government as decision maker, and really government bureaucrat as decision maker. And that's why you get crazy inconsistent decisions like registration of the devil is a Democrat, but a refusal to register Satan is a Republican because that's disparaging. It seems to me that at a minimum they got that backwards. But even if they did, it's really hard to draw a distinction based on anything other than whim of examiner or examiner's belief as to what is a fair or not fair thing to say. So, to me, I think this is viewpoint-based discrimination. At a bare minimum, it's content-based discrimination. From a perspective of this case and the survival of 2A, it doesn't matter. Because there is no way that this law can pass strict scrutiny, even under a content-based as opposed to a viewpoint-based determination. The government has offered no interest to justify the rule other than the suppression of speech itself. And that's not a permissible interest to justify a content-based restriction. You can come up with a good reason to impose a content-based restriction that is unrelated to the suppression of the speech. But you're not entitled to say, we suppress the speech because it's bad speech, and justify a strict scrutiny on that basis. And that's precisely what the government has done, right? The motive is to suppress the speech. Even if it weren't, it seems to me there are clearly less restrictive alternatives available to the government besides refusing the registration altogether. If, in fact, the government, as it has argued, says, well, we don't want to be associated with this speech, it's perfectly easy for them to disassociate with themselves from the speech. They could say, affirmatively on the front of every trademark, we do not endorse. They could even probably get away, constitutionally, with saying only on the ones they really don't like, we do not endorse, right? And therefore make a judgment of what they want to affirmatively be implicitly endorsing. But I don't think there's any way in which they can say they can survive strict scrutiny. Even the not quite as strict as super strict scrutiny that we apply to content rather than viewpoint-based discrimination, when they can't articulate a reason for doing this other than this speech offends me or it offends a group of people and so we want it suppressed. That is particularly true, I think, because as the Dykes on Bikes brief indicates, but as many other examples also show, trademarks are not just commercial speech. Right? I don't think it matters under current First Amendment law, although I confess that I'm not entirely confident of this, whether we put it in what used to be the commercial speech bucket or not, because we're kind of squishing that bucket together into the normal speech bucket. But even if we said commercial speech should be easier to regulate in various respects, lots of things about trademark law are not, in fact, commercial speech. A clear example of that is Dykes on Bikes, right? Where the purpose of this registration for a nonprofit political organization is to be able to communicate a political message and to prevent other people from trying to appropriate that message either for commercial ends or to change what the message says. Now, Rebecca correctly points out that there's plenty of speech interests on the other side too, and that one of the things that a lot of trademark lawyers tend to gloss over is the fact that trademark law can both promote and encourage speech, but it certainly can also repress it. But I think that fact doesn't change the fact that what we're doing when we regulate disparaging speech is regulating not just commercial transactions, commercial speech in the purest, narrowest sense. We're regulating things that have real expressive impact from both the speaker's and the listener's perspective. So, what the government and the defenders have to fall back on is the idea that, well, you know what, this isn't actually a speech regulation at all. If it is a speech regulation, I think it pretty clearly fails the First Amendment. Maybe it's just a government benefit. We're just giving you a benefit, and we can withdraw that benefit without having to worry about the constitutionality of the speech. Now, I think there are a couple of problems with that argument. The first problem is where Rebecca starts, that is, it might not be true. Right? That is, Judge Moore's opinion for the en banc Federal Circuit goes through the question of whether you can actually bring a 43A claim for something that has failed Section 2A. It's not obvious that we know the answer to that question. We have all, at least I have, kind of assumed that the answer is yeah, you could still have unregistered mark protection. But it turns out there aren't any cases that say that. And if you think about it, most of the other aspects of Section 2 we have incorporated by reference into Section 43A. It's not all that surprising to think then that we would incorporate this one too and say, well, if you can't have a mark because of 2A, you're not going to be able to get 43A anyway. I think if that turns out to be true, the government's case collapses, and I think Rebecca would probably agree with that. That is, if it turns out, she'll have 3 minutes to disagree with. It seems to me that if you're restricting not just the ability to get a registration benefit, but you're actually saying no mark at all, you do not get to use your mark at all and enforce it, that strikes me as well beyond the unconstitutional conditions did I grant you a benefit doctrine. Even if you don't go there, and I don't think we should go there necessarily, right? This isn't just a government benefit. It's not a grant of money. It has real significant consequences in enforcement. So one of the things we point out in the Dykes on Bikes brief is that it was essentially impossible for a small nonprofit organization to prevent blatant knockoffs without a trademark registration. That when you go to eBay or Etsy or Cafe Press or any of a number of other companies and say, hey, these people are using my exact mark, my exact logo in a way that competes with me, they say, fine, show me your trademark registration. And if you can't show them a trademark registration, they say, go away. And I think there's a perfectly reasonable basis for them to make that decision, right? They don't know who has common law rights. They don't know how far those rights extend. They don't know who the first user is. If I bring them a government registration and say, look, I am the owner of this mark, arguably they don't really know those things anyway, but at least they have some greater certainty and they're comfortable doing it. So the practical effect of registration is not just I get additional remedies, I can get customs to enforce my rights, I get a nominal presumption of validity. As a practical matter, for many trademark owners, it is the difference between effective enforcement when you can't afford to sue everybody and the lack of effective enforcement when you can't afford to sue everybody. But I think even if that weren't true, the unconstitutional conditions cases don't necessarily apply here, because the Supreme Court has made it pretty clear that just because I can impose a harm on you in certain respects doesn't mean I can do it for reasons or purposes that are themselves directed at the suppression of speech. In the Perry versus Sinderman case, for instance, the court said, even though a person has no right to a valuable government benefit, and even though the government may deny him the benefit for any number of reasons, there are some reasons on which the government may not rely. It may not deny a benefit to a person on a basis that infringes constitutionally protected interests, especially his interest in freedom of speech. Right? So, yes, you can impose a condition on the grant of a government benefit, but the condition can't be give up your free speech rights. It can't be give up your constitutionally protected rights. Similarly, in Sorrell versus IMS Health, the court said lawmakers may no more silence unwanted speech by burdening its utterance than by censoring its content. Right? And that suggests to me that what we're doing is actually trying to make it harder for you to speak. Not impossible. Rebecca is correct. You could still use the term slant even if you couldn't have it as a mark, and you can still perhaps use it and get common law protection. But if we deliberately make it harder for you to use it, if we try to push you away from this mark and towards non-disparaging marks because of the content, unconstitutional conditions law is not going to protect you. That is still going to be impermissible. And at the end of the day, I think the real problem is that even if we try to fit this in the unconstitutional conditions doctrine, it's not going to get you out of the scrutiny that's going to be required where you do it on this purpose, for this purpose. And in United States versus Playboy, the court says the distinction between laws burdening and laws banning speech is but a matter of degree. The government's content-based burdens must satisfy the same rigorous scrutiny as its content-based bans. Right? And as I've suggested earlier, you can't meet that burden. I don't think you can come close. That leads me to the last point, and where I think Rebecca's argument is sort of at its deepest and most profound, and that is well, if this is unconstitutional, what else goes down with it? And now, this is a slippery slope argument. My friend Eugene Volokh has described slippery slope arguments as having the structure refusing to do the right thing today for fear of being forced to do the right thing tomorrow. Whether or not that's generally true, I think it is precisely true in this case. That is, if you ask the question, what would happen if we actually were to apply a more rigorous First Amendment to a lot of areas of trademark law, I think, and I think honestly that Rebecca thinks, that most of those results would be salutary. That, you know what, yeah, it's true that in addition to disparaging, we might also lose the ban on scandalous marks. Right? You could register cocksucker, something we banned 4 years ago in the Federal Circuit. I'm okay with that. You could register a mark that included a state flag as part of the element. I'm okay with that too. Right? You could, I think, draw a distinction between the things that we think are central to trademark law because they're about consumer confusion and the things that are in fact really restrictions of speech. And one of the benefits of drawing that conclusion would be precisely that it would benefit defendants in trademark cases at least as much as it would benefit trademark owners. While the plaintiff here is the trademark owner, understanding that talking about that using a speech is something that actually triggers real scrutiny under the First Amendment, I think would give us better results in the vast majority of cases. Now, there is a risk, and I think Rebecca is right to say that there is a risk, that the court could just throw up its hands and say, boy, we're not going to allow you to justify even the core aspects of consumer confusion or requirements for protection or genericness because all of those in some sense burden speech. I think there is a way to draw that line, even under the Supreme Court's most robust First Amendment cases. I personally think some of those cases, like the Stolen Valor case, are too robust, and I hope they will back down from them. But one way that would be easy and simple to draw that line, one way that I think would make the rest of trademark law survive, would be to decide this case on the basis that this is viewpoint neutral and not content neutral. You wouldn't have to reach all of content neutrality and say these other things might also be not content neutral. All you'd have to say is the government is trying to suppress speech, and that's not permissible.
discrimination. Other groups are protected to the exact same extent as Native Americans. That's not viewpoint-based because it doesn't promote any group over any other group or any ideology over any other ideology. It's content-based, sure, same as the rest of trademark law. And I want to call your attention to all Mark's quotes about prohibitions and bans and suppressions and punishment. These quotes and the cases from which they come make total sense when you're talking about sending people to jail or fining them, burdening them for their speech. But the government deciding not to include specific words or symbols in its program is different. If Tam couldn't get a registration until he gave up using slants, then everything Mark said would be absolutely right. But he can, so it isn't. Sorrell says that disagreement with the message of something leads to heightened scrutiny if the government acts on that basis. But consider this statement. The Holocaust happened. Can public schools teach that without being subject to strict scrutiny? Can they give you a bad grade for claiming that it didn't? We don't want to impose that standard of justification on the government when the government is creating the program. And that's why we have the doctrine of unconstitutional conditions, to allow it to take certain positions as long as it doesn't affect speech outside the program. You can fund abortion and not contraception, or vice versa. You can fund democracy promotion, but not authoritarianism, or maybe vice versa, as we may find out. If the government is going to run it all, you actually have to let it make choices about what it's going to fund. In terms of content-based discrimination, yeah, all trademark law, with the exception of utilitarian functionality, is content-based. That's the problem. I do think that the rest of trademark registration can't survive strict scrutiny. The less restrictive alternative will always be using fraud, or even the common law, to the extent it goes beyond fraud. This goes back to the government deciding to have a program where it will intervene in the market. Now, Mark says that the vagueness of disparagement is why you get crazy, inconsistent decisions, but it's not. The size of the program and the fact that the program is evaluating 500,000 marks a year is why you get crazy, inconsistent decisions. And this is why a decision about disparagement is not just a decision about disparagement. I will say a couple more things. I do think that there's a valid government interest here, non-participation in disparagement by the government. I think there is a tradition in our law, including Shelley versus Kramer, of saying that the government should be hands-off of things that are destructive to the social fabric. He says that what we're doing when we regulate disparaging speech is regulating things with real expressive impact. But that's the point. There's no neutral position from which to evaluate a rights-granting program. And so many of these arguments assume that there's some neutral, non-interventionistic way of having a registration system, which is a contradiction in terms. Now, at the end, Mark says, if we applied the rigorous First Amendment, most results would be salutary, and that I would agree. I like that with infringement and dilution, sure. But I don't so much like that with ITUs and nationwide protection and extension of protection under the Paris Convention, none of which could survive strict scrutiny. And it's actually debatable whether they could survive intermediate scrutiny. And here's the rub. Trademark plaintiffs get to yell property rights as a separate interest and not have the same First Amendment rules apply to them. So I don't think we necessarily get our cake if we accept this, to me, let's call it lima beans. And I will note, for that purpose, the majority in TAM said outright that protecting investment was one of the two okay purposes of trademark law. So we're just not going to get what we want out of this. I mean, I do think the result may well be that the Supreme Court just lies about the difference between the two regimes, and maybe that's the least bad result.
So we've got like 15 minutes for questions. So, yep, go ahead.
So I got a small question for Mark and a small question for Rebecca. Mark, why doesn't the Supreme Court just pretend that trademarks are just like copyrights and give this the find some traditional contour they can hang it on and say we're just going to keep hands off the system. There's enough First Amendment protection in the system that we can tolerate this potential problem. For Rebecca, you recently blogged about the UHS of Delaware case that seems to treat pleading standards significantly different for 32A registrations and 43A unfair competition. Does that shift your perspective if that gets more broadly adopted, that there might be some real harm to plaintiffs who can't, or to trademark owners who can't get registrations?
All right, so Jake's question to me, I think, is the inverse of the slippery slope idea. So the idea here is we should do the wrong thing today because we did the wrong thing yesterday. And apart from the fact that it would be wrong, which I fear is not enough to get the Supreme Court to reject it, I do think there are substantial differences, right, that explain why the court has not actually said, oh, trademark law, like copyright law, gets a First Amendment free ride. Right? One is that you've actually built in things that explicitly protect speech in pretty clear ways to copyright law, but not to trademark law. Right? The fair use doctrine in copyright law might or might not be a sufficient protection that we shouldn't worry about the First Amendment. I don't think it is. But it is at least an effort to protect people who affirmatively make expressive uses of someone else's work for their own expressive purposes. Trademark law doesn't have those things built into it. We've created some defenses as a matter of common law, maybe, but I think the court's going to be reluctant to say it. But I think there's another reason. I also don't find this a terribly persuasive distinction, but I don't find it persuasive on the copyright side. And that is that the court, I think, is influenced by the existence of the patent and copyright clause in the Constitution. Right? And so it's trying to harmonize what it views as sort of co-equal provisions in the Constitution. I don't think it could even say with a straight face that it was trying to do the same thing with the Commerce Clause. Right? Because if it does that, it throws out all of First Amendment jurisprudence.
So, Jake's question to me was about 43 standards. I don't think that makes any difference at all because I think it's okay not to give Section 43 protection to disparaging marks. So, opening up the gap further doesn't make any difference to me. I will say, however, that the fact that you don't have to show harm for 32 is an example of the destabilizing or the assumptions that we make that are completely crazy from a traditional First Amendment perspective, that you wouldn't have to show harm. I mean, United States versus Alvarez is all about that, and I mean, maybe that'd be a good thing, but I don't think that the way we get that is by blowing up registration.
So, guess I have two questions, mostly for Rebecca. The first is just to push back a little bit on whether it matters who's filing with regard to disparagement. And because you're right, maybe it's just the sort of vagaries of who gets it, but it does seem that the perspective is really based on who's filing it. So Dykes on Bikes, even though it was initially declined, ultimately it was reversed because of who was filing it. If another group had filed it, I think it would have come out differently. I don't think we can, despite Mark's persuasive brief, argue that all gay or bisexual women will find Dykes to not be disparaging. So I think that there is some viewpoint discrimination. I think that, at least I've documented, some other people have documented, I think there's sort of disfavoring of things that are, I think, are more sort of pro-female sexuality. Game cocksucker was registered. I mean, some of those things are just bizarre. Some of them have to do with better lawyers, but I think some of them actually have views on particular types of words and whether they're disparaging or not. So that's one question. And my second is, even if it's just content-based, which it is, clearly, and not viewpoint discrimination, I'm not convinced by your justification of the government interest because it's not government speech. And so the marks, the whole basis of your argument is that it's not ultimately respecting speech, which may ultimately convince the Supreme Court actually in your favor. But since they get to say it anyway, they get to continue to use it, they're not taking the disparaging marks that you're concerned about out of the world, and it's not government speech. So I'd like your sort of amplification about the interest.
So, great. So, frankly, I just don't think the record bears out your claim that it matters who files. I mean, first of all, we have basically spotty information on this. But, the Democrat and Republican examples are all things that got through by people who hated the people, right, on the other side. not to mention all the bitch and anti-woman marks. I mean, those just go different ways, and yes, there's inconsistency, but I don't think there is a patterned inconsistency of that type. So the second question, I think the government interest is a really interesting question, I think there's a difference between what the public perceives in terms of endorsement and what the government might have an interest in holding to be true as a substantive value. So I think it's probably safe to say that the government, that people don't understand what registration is, right? We've all had these contacts with people from the press who couldn't tell a patent from a trademark from a copyright, much less a registration from a trademark right. But by that standard, yeah, like the government is expressing nothing. On the other hand, the government is expressing something about what helps the orderly flow of commerce. And it's not expressing it to consumers, it's expressing it to lawyers and to the system itself. And this is what leads me to talk about Shelley versus Kramer, that Shelley versus Kramer is a case about what kinds of beliefs about people the government can accept as reasonable without it. And Shelley says, no, basically, you can't accept the proposition that racial differences have effects on land values, because that would be, accepting that would be discrimination by the government itself. I think there's a similar value at work here. Now, I see how you could go the other way. I don't think it'd be crazy to go the other way, but on balance, that seems good enough to me, given that this is not a suppression of speech.
Why isn't this the opposite of Shelley versus Kramer, though, right? I mean, so Shelley versus Kramer says the government can't have this message. Your argument to justify this is the government gets to impose a restriction precisely because it is communicating a message, right? And I can imagine circumstances in which the government is communicating a message. So maybe the license plate, the choice of what's a 5 license plates. Harder for me to see that in the trademark context of when there are 500,000.
Right. So this again is the sort of government program weirdness of it, right? So Shelley versus Kramer is actually about the government program of operating a court system that enforces contracts. Here, it's a more elaborate system, and you're saying it's suppression. I'm saying the government shouldn't grant rights in disparaging terms, because it's that active granting of the right which you then deploy in other contexts that actually is similar to the Shelley situation, where the government will or will not give effect to a private covenant.
I'll start by saying I agree with Rebecca. I signed the brief. Link the schools to the trademark registration. A child walking with a Dyson by t-shirt going to school will be sent home under a public school, because that word will not be allowed in a public school. Probably the slangs, the N-words, the popular and whatever. So the government, the public school will completely suppress speech.
So I think, yeah.
And so how do we reconcile that?
Right. So, well, I think there are 2 ways to reconcile it. So the first thing to note is, I think that's true in an elementary school. I think it's true in a high school, although it probably shouldn't be. I think it's almost certainly untrue in a college. Right? That is, if I walk into a public university wearing a Dykes on Bikes t-shirt and they throw me out, I bet I've got a First Amendment claim that is a slam dunk winner. So what's different to me, I think, is that we pretend that kids aren't actually actual people, and that it's okay to suppress speech where kids are involved. And cases like Tinker versus Des Moines notwithstanding, right? I mean, so there, we've got, the Bethel versus Frazier case where a very mildly racy speech while running for high school class president gets you punished, and the court basically says, First Amendment, no, these are high school kids. They don't have real speech rights. I think they're wrong to say that, but I think it would stop at the school doors. That there's no way we'd extend it to adults.
So, just after reading a bunch of cases, rather than, as Rebecca says, there being a sense of it matters who files, my sense became it mattered if someone complained. That seemed to be the difference for a lot of other seemingly inconsistent outcomes. I wondered if either of you had the sense that might be relevant.
I mean, so it's hard to know. I think that certainly matters, and this is consistent with Rebecca's story that this is just a kind of overwhelmed bureaucracy, and so if somebody pops up and says there's an opponent, right, they're more likely to get attention. In the Dykes on Bikes case, there was one guy who filed an opposition because he thought lesbianism was bad. And he ultimately lost that opposition for lack of standing because he couldn't show injury. There's another year of the Odyssey, right? So I think there is clearly something to that, but I actually want to sort of go back to Jennifer's point. I'd be very interesting to study this in an empirical way, right? But my sense is the same as Jennifer's, right? Which is this is not a neutrally applied rule, right? This is a rule that is actually gendered, right? This is a rule that does actually, even as it is supposedly protecting minority and disadvantaged groups, right? Do it in ways that systematically sort of reinforce some standards rather than undermine.
I wonder if you can each step away from your advocacy positions for a moment and give us instead a prediction, especially on the in-person court.
They're going to affirm. Breyer is going to say essentially what I said about balancing, like that given what this is about, it's too vague. And some combination of other people are going to make up something about how this is not the same as every other part of the system.
Well, so I agree they're going to affirm. And to me, the real question is, do they address the every other part of the system question, right? So I think a reasonable conclusion would be they say, this is viewpoint discrimination, it goes down. Even if they don't say that, they say it's content discrimination, your justifications for it are based in suppression of speech, that doesn't work, it goes down. And that they don't say anything one way or the other about descriptiveness versus suggestiveness or generic marks or any of the things Rebecca's concerned about. That said, I think as a practical matter, there's not all that much reason to be concerned about those. That is, I don't think a court is gonna, I don't think this court will reach out and say, oh, and by the way, registration is unconstitutional. I think beyond scandalous marks, which will pretty clearly rise or fall with this, and maybe emblem or insignia, that where there is a plausible confusion-based or consumer search cost-based justification, that the courts are just going to continue the trademark law there largely as it is, and they're not even really going to think much about the First Amendment.
Yes.
And I could be wrong, but...
So actually, I largely agree with that descriptively, but again, this offends me as someone who's interested in law as a system of rules, right? So if I can't give a good reason, or if the reasons that are given to me are plainly just not true, then I think we have moved away from law, and not towards politics, but towards something even more inchoate, like I like this and I don't like that, and especially in the First Amendment context, that seems to me be a bad thing, independently.
That seems to me to be the First Amendment.
Yes.
Why I'm not a First Amendment scholar.
So I do think that underlying this is a very serious question of what it is that we think the legislature ought to be allowed to do, and the difference between speech and non-speech activities. And the reason we're getting all these flashpoints is because this is commercial activity carried out through speech, right? So we're having a fight about Lochner, and it's a very fraught one. And I actually will say, I think my commitments here are not completely aligned with what I'd like Congress to do, because Congress isn't going to be filled with people that I like for a long time. So, but that's where I end up.
So the question's from Mark, and the basic question is what the government is doing here suppressing speech by not registering? By not registering, right, granting a trademark gives TAM the right to suppress others' speech. It strikes me that on balance, granting the trademark suppresses more speech than it encourages. So, that's a basic question. is this suppressing speech, or is it in fact, by not granting the registration, isn't that unburdening more?
This is true of all, this is always true in the IP system, right? There's sort of speech interests on both sides. What I would say is, it is burdening Tam's speech, and it is deliberately trying to shunt him towards certain types of speech rather than others, right? Those things strike me as problematic under the First Amendment, even if, as you suggest, the result of not denying him a registration might be, hey, there's more infringement. There's somebody else sets up a rock band and calls itself the Slants, right? I think you're absolutely right to say there's a speech interest on both sides. I don't think we can just sort of add them up and say, well, you know what, kind of on balance, we got more speech if the government imposed Rule X than if it imposed Rule Y, and therefore what the government rule is not a speech restriction, because a government rule that affirmatively burdens speech by one party and tries to direct them to use a different word instead is still messing with the market for free speech. Right now, the problem, of course, is that sort of we are not operating in a free marketplace of ideas, right? Because all of IP is already an imposition or a burden on the marketplace of speech. I think it's a fair concern.
Yeah, so let me just reframe this. It is also true that the registration shunts potential defendants towards certain types of speech rather than other types. Right? That's why we have the register. Again, there's no neutral framework. I think Mark is right that it is impossible to add this up in some way as if we could. We should probably look to reasons instead. And then one of our disagreements is about whether the government's reasons here are okay.
Joe, last question.
I have an institutional counterfactual about vagueness, and I apologize for my voice. It's not in its best form. Here's the counterfactual. The agency is very weak, like the Patent Office, and is restricted to rules governing the conduct of proceedings. It can't write substantive rules. And I wonder in an alternate universe where the Trademark Office were like the EPA or the SEC, perhaps Rebecca would say, it would have been even more clear, even earlier, this is all fine. Or Mark would say, it would have been even more clear, even earlier, that this is a pile of bunk. I'm just wondering what you think about trying to articulate in a more code-like way what's okay and what's not okay. Would that have helped?
So it would have helped if you think the problem is vagueness. It would not have helped if you think that the problem is a substantive burden on speech, right? So affirmatively saying, we will not actually let you choose the following list of marks gives more clarity. I don't think it means there's less of a speech restriction. If anything, it might mean there's more of a speech restriction.
And so let me just say, it's really hard to figure out what a code is in part because the PTO's position that every mark is a tub on its own bottom actually makes a lot of sense in that the reasons that one symbol might not be registrable are often going to be completely different from the reasons that the next symbol is not going to be registrable. So, and the Tarascos situation is just a kind of weird outgrowth of that. But which is to say, it may be really hard to do more than you get in the TMEP, where they do try and come close to giving examples and so on. But people are what's the line in Qualitext? Like they're infinitely creative in the use of symbols. So no code is ever going to get it done.
So let me just say one final thing on that point, right? Which is, I think if we actually did manage to code it out in a way that was clear to people what was permitted and what was not permitted, that would make even more clear that this was in fact the government making a decision as to what they liked and what they didn't like. And that's what strikes me as problematic.
Well, good. Well, I want to thank both of our equal twins. Was not disparaging.
Wait, so which one of us gets the good twin?
So that's a good,
Which is the
and you
evil
can tell, it's tough to tell, but it's coded in a very minor. So these are trinkets from us to use so that you can tell your friends that you're evil twins. Or not, one of the two. So thank you very much. I know we've got a reception to follow. Thank you for coming.